How you doing, and welcome back to Undertaker 365. I'm Jacob Vandenberg. I'm a licensed funeral director, and I'm the host of the series. The purpose of this video right now is to disclose to you some information that is a disclaimer about what our series is and what you can expect moving forward. Understanding that we're talking about the funeral industry, there's some extremely sensitive topics that we're going to be covering, and I want you as the viewer to understand that the information I'm disclosing to you is strictly informational. This is my opinion. The opinions that we express are solely coming from Undertaker 365 and me, Jacob Vandenberg, and certainly our field experts that we're interviewing. So with that, I encourage you to read our viewer disclaimer, understand that this is viewer discretion, and that we are covering a lot of sensitive topics, but really we want to be transparent about it and make sure that you understand that we're providing information based upon our opinions. So thank you very much. Can't tell, I'm pretty excited about today's episode. Welcome back to Undertaker 365. I'm your host, Jacob Vandenberg. Today we are meeting with a really good friend of mine, Dave Anders from Hutchison, Anderson, Hickey law firm here in Tinley Park. We're going to cover a wide array of content regarding to legal questions and legal processes when it comes to leading up to the death of a loved one, estate planning, and what to expect following the death of that person. I'm really excited because it's presenting a lot of information to you so that you can prepare yourself, prepare your family as you go on that process. With that, I'd like to put a little plug in for my friends here, Dave Anders, his staff, and the rest of the legal team at Hutchison, Anderson, Hickey, and understand that they're there to help you. They're there to answer your legal questions, but really they're doing it because they're a part of the community. They've been a part of the community for a very long time. I would highly suggest that you reach out to them and start your estate planning, start your life planning, and have a good conversation with them. Thanks again for tuning in.
Hey friends, and welcome back to a new episode of Undertaker 365. This is Jacob Vandenberg. I'm seated next to a good friend of mine from Hutchison, Anderson, Hickey law firm, Dave Anders. So Dave, I just want to say thanks for coming aboard and participating in today's episode.
My pleasure.
We have a lot to discuss, and it's all extremely informative information for you and your family to make some advanced planning before death, and then certainly some after planning and how to go about your estate planning and whatnot. So I just like to dive right into it. We have a lot of information to cover today, and again, I'm really honored to be here with you today, Dave, and just turn it over to you for a general introduction, if you could.
Right, thank you. I'm Dave Anders. I have practice here in Tinley Park, Hutchison, Anderson, Hickey. I've been in the Tinley Park area practicing in Tinley Park for 35 years. I grew up in Tinley Park, went to Tinley Park High School, finished law school, and came right out here and started working. So I love working in Tinley Park, and I love the people in this area, and really enjoyed my practice. We have a general practice, and we do quite a bit of estate planning and wills and probate, and the things associated with some of the aspects that get relevant in the funeral business. So.
Yeah, I mean, we worked a number of times together. I've often recommended families to come to you, obviously. You guys do great work. But a part of that recommendation, I think, and you hit it on the head, and the reason why I think your practice is important to Tinley and the surrounding areas is that you're from the area. You kind of get what's going on. You know the needs of the community in reference to the different types of demographics and the situations that people might run into when it comes to planning their life and the situations they run into. So for today, I want to cover a couple of key areas. Obviously, we have the pre-death situation, so planning before somebody in your family has passed or yourself has passed. We have the at need, the time when somebody has passed away, and the conversations legally that come up when it comes to that. And then we have the after somebody's passed or somebody's the aftercare, so to speak, situation when it comes to the legal sides of the decisions that you have to make. So that's why we brought in our field expert. We have Dave here. He's going to go through a series of situations that you might run into. And first, right out of the gate, I think it's important to talk about power of attorney in the state of Illinois. The two powers of the POA, the two different types of POAs being health and finance. They're very, there's a distinct difference between the two of them. And I think it's important for you to kind of give the viewer a rundown of what that is and how they can go about setting one up, and then how it applies to their needs.
Okay. Well, first of all, there's two powers of attorneys. There's statutory powers of attorneys for healthcare and for property. They are both set up in the statutes of the state of Illinois. So first with the healthcare, the concept is that while you are alive, if you become incompetent and cannot make decisions for yourself, who is going to make those decisions for you? And so with the power of attorney for healthcare, and we'll start with that one, what that will dictate is somebody who then can make healthcare decisions for you when you are not able to make them on your own. And you can't have people. They are to be in order. So you pick a person, and then there will be a backup and another backup. And I typically do ask my principals, which is the person doing the power of attorney, I typically ask them to make sure they provide me at least those three people. So that a lot of times it's the spouse, the first choice,
Right.
and then the backup may be kids or friends or other relatives. So I definitely like to have the three total agents to be on the form.
Sure.
Now the form you can limit it, you can restrict it, you can put in your wishes with respect to what treatments you're willing to have, not have, whether very similar to some of the things that you might see in a hospital. But in this case, you can set this up to determine, and a lot of it is for end of life. There's a specific paragraph in there about your position on the end of life, and it's a general position. One of the most important things with a power of attorney for healthcare, and I very strongly counsel my principals to do this, is you have to have the conversation with your agents, how you feel, what you're willing to do, what you don't want to do, what you don't want them to do on your behalf.
That's an awkward conversation.
Many people put that off for years because they don't
Right.
want to have that conversation.
Right.
But I will say that in my experience, whenever I've had to talk to anybody who has had to go through the process of utilizing their power of attorney for healthcare and make decisions on behalf of, even life and death decisions on behalf of a principal, they have been extremely comforted in the fact that they knew what the principal wanted. So it takes a very difficult situation, and it does at least provide a little comfort for the agent if you've had that conversation.
Could we pause here and just inject in a little something? Let's kind of walk through a scenario, and I think this is rather important because we're not talking about. I mean, we are talking about situations where I think it's when somebody is walking that path of life and they are coming to the near death and having to make some decisions for that. But it's also important to have just as a person, because if you're going in for routine surgery and you're going to be any type of anesthesia, I mean, you need to have somebody making decisions for you underneath that situation. Like you said, that in the first sentence, competent, sound mind, thinking, you're able to make decisions for yourself. Right. You're not in that scenario, and I think a lot of people miss that.
Yeah, that's very true. These are not things that just older people should have. I mean, really, any adult should have these.
Sure.
Should absolutely have them. You could get in a car accident. You could have a lot of things happen to you while you're young. So this is certainly, you're absolutely right. This is not something that is just for the older people as they get toward the end of their lives. Right. They should have these. These are something that it should be part of every couple's or individual's estate planning documents, and they should be done as soon as really anybody's an adult.
Absolutely. So you mentioned there's a difference. There's healthcare, and then we have financial.
Yeah. So the healthcare, just basically you can put in all the information you want, anything you want to restrict, anything, you set it up, and then that healthcare power of attorney, it's really a good idea, and I also counsel my principals to do this, is to circulate this, because there's no real downside. Copies are as good as originals, so there's no problem with getting this circulated. So you put it in the hands of your agents, put it in the hands of your doctor if you have a regular doctor, so that this thing is out there. And if it ever needs, in a crisis, an emergency situation, somebody's going to be able to put their hands on it quickly so that the agent can act and not potentially have a delay.
Two things for this one. Is there, in this packet or in this this document, does it go over a DNR at all?
It generally talks about quality of life issues and end of life situations, but it doesn't go into all the same exact things that a DNR would. But you can include things in here.
So you can add to it.
You can add to it, yes. So if you specifically say, I would never want a trach, I don't want to be on a feeding tube, I don't want an autopsy after I pass, all these things can be, if you want them, you can add them into your power of attorney for healthcare.
Okay, and the one thing I will add to then, for the funeral professionals and for the community to understand is that when the end of life does happen and there's a situation where a next of kin is not a part of the conversation, in the document for power of attorney for health, the funeral home or funeral director is going to be looking for the line that specifically talks about disposition, and I think that's important. Probably the next part of our conversation, discussing that at end of life, this document is not the end all be all for the person making decisions. Correct?
And obviously there's this gap. So a power of attorney, both of these powers of attorneys terminate upon the death of the principal. So you have that gap. So once the principal passes, the power of attorney is technically not valid. Now, to the extent that it provides information about disposition, that's helpful for everybody going down the road, and to administer and to deal with things like planning the funeral.
And most of the times when we run into situations where the individual doesn't have a specific next of kin, there's not a familial next of kin. The power of attorney, 9 times out of 10, they're probably going to have a will with an executor, and they may be different, and the executor may be referencing back to this to find out the method of disposition. Is that something that you'd probably run into?
So I certainly try to get my clients to make those things consistent. So so that they don't have a situation where the executor is going to be so totally different and out of the loop compared to what the agent was in the power of attorney, because that's just a problem for that exact situation that you set up. Somebody without family who is now relying on, and if the executor doesn't get named instantly, you have to actually go into court and have a probate opened up and have the executor named, which we can do fairly quickly, but it's 3 or 4 weeks.
Right.
So it's not that same day. So you have that gap.
That's going to be a good topic that we're gonna follow up with when it comes to probate. It all intertwines together, but if you have all of your documentation in line and you have the professionals that are directing you and telling you what you need to have, you're not going to have those situations, and everything should work flawlessly and seamless. Right.
That's what we try to get. We try to make that easy for them.
That's the goal, right?
Yes, that is the goal.
We know that doesn't work all the time, but we try. No. So we have the healthcare. I think we talked a lot about that. What is the financial?
The other one is the power of attorney for property. Again, it's statutory, and it's the same concept. You choose an agent, one person, and then you have your backups. And again, with this, you can limit it. You can use it for a particular instance. If you're going to go out of the country for a month and you need somebody to finish a real estate deal for you, you can strike all these other parts of it and only have it good for a real estate. You can leave it totally open and let your agent handle any property or financial situations that may arise. But that, again, is something that the principal can go through and direct. We typically put language in here as to when this will be effective. Most of the time, we have the powers of attorney for property be effective and triggered by a writing from a doctor saying that the principal is no longer able to make decisions on his or her own. A live power of attorney can be abused, and so we try to minimize that situation by having that trigger in there that the doctor's got to get involved. Again, the power of attorney for property terminates on the death of the principal, so you will not then be able to use this to access financial accounts to finish real estate deals if the principal has passed. So, and again, this document is extremely helpful. We try to make them consistent. We get information out and we circulate these among the agents so that they have them and that they're able to utilize them if they need to.
So I think what I'm hearing is that if there's nothing else that you take from today, it's extremely important as an individual to have these two documents in place, have your agents that are going to be representing you in the off chance that you're not able to represent yourself. You know, so that's not only important to the funeral industry, but that's really important as a community and society to make sure that you have people that are sound mind that are able to represent you in a challenging point for yourself. So thanks for covering these two topics.
Okay.
I'd like to shift gears a little bit. We talked a little bit about executors.
Right.
This probably is one of the larger topics to talk about when it comes to estate planning, planning for your life, planning for your afterlife, and how that whole situation works for your family. It's, I'm assuming, pretty complex, but if we could break it down a little bit, we have wills, we have living wills, we have estate and all that. I mean, there's so much information there. I just
So it's really simple. When I talk to a client, the idea is your estate planning. When I die, who gets my house and my money and my stuff? And how do I get it to them? That's kind of what, how do you get it to them easily, as cost effectively as possible? And that's kind of what you're looking at. So out in this area, a lot of my clients have a home, a little retirement, some money, and then their stuff, right? And it's not, we don't have, I don't have a bunch of really, really wealthy clients. They're all relatively modest,
Sure.
but that's what they have. So there's several ways you can estate plan. One of the easiest ways, and really a very effective way, is just by titling your assets. So first of all, husband and a wife own a home. They own it jointly. If one of them passes, the other gets it automatically as a matter of law. So that's kind of simple. One of the things you do with a bank account, you may have husband and wife joint on a bank account, and then you name your children as your contingent or secondary beneficiaries on those accounts, so that when the death of the second of the parents, the money is just, they're the beneficiaries. They get it. Similar with life insurance policies, you can do those beneficiary designations on just about everything, and to the extent that that's what you want to happen, that makes a lot of sense. I also, often recommend that you put, if one of the spouses is widowed and there's just one parent left, that they add a child to a checking account. It's just, again, it's a convenience factor, and the idea being that helps with that gap area. If a child has access to funds, they can, after parents have passed and before any wills get probated, they can access those funds and they'll be able to manage some of these
financials,
right?
Because there's a handful of them that,
That
obviously
come
you have
up.
the funeral expenses, but yet there's a lot of other things. I mean, if the person was still had vehicle or mortgage or things like that, I mean, those are things that you still want to stay current with.
Right. So that's very helpful. So and one of the things now that the legislature's come up with is a transfer on death instrument, which now allows people for their residents to be able to name essentially a beneficiary. So you record a document with the recorder of deeds, just like the deed that put you in title in the first place, that says, so let's assume again a husband and a wife, that the husband and wife are owners of this home, it's their residence, and on the death of the second of them, if they still own this home as their residence, it will then go to, and you name who you want. And that's really a nice feature and a nice, the legislature did something really smart there, and that was really helpful for our estate planning, because so often clients were naming beneficiaries on their bank accounts and their life insurance, but they still had this house, and they were then having to open a probate to deal with the house. The transfer on death instrument allows a way to get the house where you want it without having to probate the house. Now, the little caveat to that, the people will own the house. So sometimes that's not a great idea. So if you have a lot of kids and they're not all on the same page, some maybe have handicaps or disabilities or addictions, or they're out of work, or some still live in the house, some live out of town, putting 5 or 6 kids as an owner of a home may not be efficient. So I always discuss that with the clients when they're talking about doing a transfer on death, because it's a great vehicle, but it's not necessarily going to be better than just letting the house go to probate if you're going to have all kinds of trouble if they are
It's
owners.
situational. I mean, you have to
It's
really have that
situa-
conversation advanced
Yes.
to kind of find out what the dynamic is. And I mean, I could speak just from the funeral conference alone, the different dynamics you deal with
Right.
in families.
Right.
In every one of those situations you just raised, I mean, it's very common,
Right.
and they're not all on the same page.
Right.
So
So that's certainly one way. Titling, just a good, thorough titling can really make this process simple and get your stuff where you want it to go very easily. But let's say that you aren't able to title everything, and you've got some commercial real estate maybe that you can't do a transfer on death with. You would do a will, and so what happens in the will, you name executors, again, the people you want to carry out the terms of your will, and you name who you want to get what. You can name specific bequests. Perhaps I want, my daughters to get the jewelry. I want my sons to get the guns. I want my, or vice versa. And I want the house to go to one of my kids because
Sure.
that kid needs it. I mean, you can be very specific. At the end of the will, after you go through any specific bequest, you set forth the rest and residue of your estate, whatever's left, and here's how I want it to go. So you set that up in a will. Now, what happens in a will, if there are assets that are not titled and have beneficiaries named, then the will establish who's getting what. And in order to make that work, the will has to be filed in the clerk of the court's office in which the decedent lived, whatever county.
Okay.
All right, and then once that's filed, then a probate estate would have to be opened up, in which the named executor in the will would be appointed executor of the estate. Now that process is really not very difficult. It's just some paperwork that we would prepare. We go to court one time, get the executor named, get this thing called letters of office, and the letters of office will allow the executor to basically step in and access any accounts, any assets, any debt, any claims, any litigation that may be out there on behalf of the decedent. So it's a key to the palace. You can do everything with it. So, and the going to probate is frankly not the end of the world. Now you hear a lot of, we got to avoid probate, But with a will that is properly drafted, names an executor, sets forth your assets, the process is as simple as I said. So you basically file the will, open the probate estate, get the executor appointed, one court date, get him appointed, him or her appointed, and then they start administering the estate. There's a claims period of 6 months, but frankly, once the 6 months is up, if there are no claims and you've administered the estate, you've liquidated, sold real estate, whatever there is to be done, then you can close the estate. So it doesn't take forever. The state doesn't get your money. The county or the clerk doesn't get your money. Attorneys, 30 or 40 years ago, used to be able to charge contingency fee arrangements on probates. No more. They're typically just hourly. You have to do hourly. So probate is not this terrible thing to avoid at all costs. It can be very complicated when there's no will, and there are all kinds of errors and people all over the place. But with a well-drafted will, the probate process is actually fairly clean, fairly simple, and gets the job done.
is it true that one of the first, if that were to be the scenario, one of the first payments that the court would order would be to pay for funeral expenses?
Funeral expense is the number one claim in the Probate Act. If there are expenses, if anybody's advanced expenses, they can be reimbursed. If the funeral home has not been paid and the estate is open, that is the number one claim. The funeral home would make a claim then in the estate and say, I have not been paid, and you make that claim within the 6 months, which it should be easy to do.
Right.
And then you are the number one. The funeral home is the number one claim.
be paid.
That gets done.
Interesting.
The statute protects that.
Interesting.
So it's a decent way to go if you have assets that you have not otherwise titled. Sometimes people don't get around to doing the titling, or they don't know who they want to title it to exactly or how, and they just don't do it. So those assets would then pass through the will and go to whoever you have set forth in the will. So that's not a bad process. Another thing you can do are these revocable living trusts. A little more complicated animal, but in certain circumstances, extremely effective. It used to be that they were more so done as an estate tax planning.
Right.
But that was back when the exemption was 600,000. I think the federal exemption is up to 10 million or something.
Yeah, they got it pretty high now.
Yeah, I just don't have any clients that have $10 million. So, from an estate tax planning, the trusts maybe are not quite as important as they maybe once were, but they also can get assets to where you want to go. And if you have some issues with second marriages, stepchildren, handicapped or addicted children, or beneficiaries that are going to get some of your estate, the trust can be very effective, but it has to be drafted. It's more expensive to do. And
that's a
like
protection.
It's a little bit of protection. Once you do the trust, and the other half of the drafting the trust is you have to fund the trust. And a lot of times, unfortunately, people are sold on the idea of a trust, and they do the trust, but they don't actually understand they got to put all their assets in the trust. You got to retitle your house into the trust, your bank accounts into the trust, the investment accounts into the trust. And now you can't change title on retirement accounts, but all these other assets you need to put into the trust so that the trust then owns the asset.
The assets.
So that then, when it comes time that you pass, the trust still owns the asset, and the successor trustee administers things.
You know, I personally have run into that a couple of times with trusts and family trusts, and it tends to be a lot of the farming community, honestly, that they have a lot of asset by acreage of land, I presume, and they want to protect it, and they've all done it that way, and it seems to work out pretty well for them. So interesting that's a different vehicle that a lot of people might not think about. Can you walk through a scenario, and I raise this because we run into it quite often. A person doesn't have any family whatsoever, and they go and meet an attorney. They have a will set up, and they name an executor, and life goes on, and that executor either just kind of departs the area or passes away themselves, and that person now passes away, and now we're kind of stuck with, what do we do?
Well, with a will, I, again, have backups. So I advise backups. So we typically try to get some backups. If a person just simply doesn't have human beings to be backups, you can try to name corporate entities to do that, but that's not as easy as it sounds, because a lot of corporate entities won't get involved in smaller estates. So, but that is one option. But you certainly want to have backups as executors for that very reason.
Would that be where the state guardian would come into play sometimes?
Well, the state guardian will come into play in the event that the person passes and doesn't really have assets. The guardian comes into play when they're alive, but they don't have assets.
Right.
Right. So they wouldn't really get involved in this.
Okay.
Once they pass.
And for the funeral directors out there, would the executor be the one? Let's say they had no children. The executor would be the one that you'd be taking direction from for the funeral planning, right?
Yeah. You absolutely would want to direct that to the executor. Now, the only problem is the executor isn't really the executor until the court appoints that person as executor.
Even though they're written down in
Even
paper.
though they're written down. So they don't have the authority. They are going to be the executor at some point, but they are not yet. So again, that kind of puts you in a little bit of a tricky spot.
Does that run into a gray area there?
Yes. So that now you have to decide, I would think, on your end, who is going to be contractually signing this thing. And the executor may have the authority, and oftentimes with families, the executor is one of the family members. But again, in the scenarios where somebody didn't have family and they named a friend as executor and they're giving some money to a charity or whatever they may be doing, that can be very complicated on your end, I would imagine, as to who is going to be responsible for the funeral expenses.
Well, certainly you have that. I mean, that I think that's probably one of the bigger things that funeral professionals would think about would be the contract. But there's also the disposition element of it. I mean, you have two choices. It's burial or cremation. Burial is reversible, cremation is not. And if you have somebody that has made a decision because you expect them to be the executor, and then it ends up being a contested situation, now we've got a big problem.
Yes, and again, I do try to counsel clients, they don't always listen, but I try to counsel them to have that discussion, put that in writing if they know what they want or they don't want. I mean, we'll have people that will put in there that I do not want to wake. I want to be cremated. And that's really helpful. They'll put it in the power, and I'll oftentimes put it in the power of attorney, and I'll have them put it in the will. And the point being then that you've kind of covered both ends while they're alive, and once, even though that there's a gap, it's going to be pretty clear what the person wanted.
Yeah.
And that certainly makes anybody dealing with you's life a little easier, because they should be able to verify that that's what they want.
Fair enough.
So that's what we try to do. That doesn't always happen. And so then you're stuck in your situation.
You mean people are not taking your counsel?
They don't even bother to come see any attorney. So I mean,
well, that's why we're doing this video.
Yes.
I think it's important that we, this isn't just a plug for Dave Anders and his law
that's
firm.
right.
This is a plug to educate people. Exactly.
You want a estate plan. You want to talk about these issues, deal with it so that you don't have loose ends that create friction and tension with family once you pass or once you become incapacitated. And it's super important. And so whether it's me or any other attorney, it's really important that anybody seeing this gets the message to take these things seriously and go talk with an attorney.
Very good. Is there anything else you'd like the community or society to know regarding estate planning or planning for the after-death scenario for a family?
I'm a big fan of gifting. And I guess my last little point of that is if you're getting toward the end of your life and you always wanted a certain piece of jewelry to go to a granddaughter or a grandfather clock to go to somebody, and you have these things and you don't need them anymore, gift them while you're alive. I'm a big fan of that. And you move them on, because one of the biggest problems is personal property in administering an estate. Because people get crazy over personal property.
Sure.
It's not proportionate to the value of the asset in most cases. But unfortunately, that is very, very, very emotional with the personal property.
That was the word I was looking for.
And that's the issue with that. So if the more you can direct those things and deal with them and handle some of that while you're alive, if you can. Obviously, you don't want to give away your money and your things while you're using them. But if you're at a point that you can afford to give away some money a little bit to some people, or to give away some personal property, things that you're not using anymore, I'm a huge fan of that. And I think it's just helpful and makes life a little easier.
Makes it easier. Well, there you have it. Tips and advice from the very own counselor, David Anders from Hutchison, Anders and Hickey. This has been a great episode of Undertaker 365. I thank you very much for all of your information for the community. If you like what you're seeing and you like what you're hearing, I can't express it enough. Like and follow our page, Undertaker 365. This is the beginning of what we feel is a very, very large movement for people to become more knowledgeable of what's going on in our community regarding the planning, the at-need, and the after-need care for funeral planning and funeral at-need cases. Again, we're here to break down the barriers and end these stereotypes of what the funeral industry is and the effects that it has on you and your family. And we're really excited to continue to move forward here. This was a great episode, a lot of good information, and we just thank you again, Dave, for taking a little bit of time.
My pleasure. Yeah,
so until next time, stay tuned, and we'll see you then. Thanks again.